Hi, everybody. This is the lecture on lesson module 3, Making Law. I'm going to go over today the 3 different types of law and how they interact with each other. And then some of this is a little bit of a history lesson. And so there's some good chunks of material from this lesson that I'm not lecturing on. You're going to need to rely on your textbook for that. I'm going to assume, because this is a 300 level course, that you know a good bit of this material already. So I'm just going to hit the parts that I think maybe a little bit less familiar to you. But if I don't cover something that you would like to have me discuss or lecture on, just let me know. Please just send me an email. I'll be happy to meet with you and talk about content that I don't cover in this lecture. Just don't want the lecture to be so long, and I don't want to waste your time. Okay, so let's just kind of go over now the objectives. These are just the things that I hope you will learn from this lesson module. You can go back and refer to that when you're studying and kind of check to see that you do, you are in fact able to do these things. Okay, so we're talking about making law. We're really just looking at what American law consists of. And the body of American law is comprised of 3, you could say 2 types of law. It just, whatever suits you, you can call it 2 or 3. It doesn't really matter. There are different types of law in America, and it matters what type you're dealing with. So that's why we're going to study each one. And I'm going to try to give you a good definition of what that type is, and then go over the characteristics of it. And then at the end, I'm going to kind of show you how they sort of interact with one another to become one single body of law. Okay, so the different types are common law, and constitutional law could be considered a subset of common law simply because there's a lot of commonality, but they are still sort of distinct, and you'll see what I mean in a second. And then we have legislation as a very distinct type of law in our country. So each of these 3 types of law can be distinguished mostly by their history and then kind of by how they're formed. So you'll see as I go through, but I'm going to try to touch on those things as I go through each one. So we start out with common law. When you hear the word common law, I want you to think of a courtroom, because that's where common law happens now. So here's a good definition of common law. I'm pretty sure I'm quoting an older version of your textbook here. It refers to the body of customs, rules, and precedent, not statutes. Customs, rules, and precedent memorialized in judicial opinions. At its center are judges, juries, and lawyers involved in the resolution of disputes, both criminal and civil. Okay, so there's a definition of what common law is, but now we're going to really talk about it. So common law comes from the resolution of disputes. That's basically all it is. 2 people disagree about some important matter. It is often an economic matter in civil law, or it would have to do with the prosecution of a criminal defendant if you're dealing with criminal law. But there's a dispute, and that dispute is going to be resolved by a judge or jury or both. And so all that resolution happens in a courtroom. It involves lawyers, it involves witnesses, tangible evidence, juries drawing factual conclusions, lawyers arguing the law, judges, making rulings on the law. That's how common law is formed. It is essentially judge-made law as a result of some sort of dispute that needed to be resolved. So how are those disputes resolved? It is by the application of norms. So in the first lesson we had for this course, you were supposed to read about the different characteristics of a culture. And some of those characteristics were morals and values, beliefs, norms. Okay. So those things, those values, beliefs, and norms are what are applied to resolve a dispute and thereby establish the common law of a culture. So a dispute arises, then a judge and jury looks at the norms and customs and traditions of the community, and they apply those customs to the dispute and come up with what they believe is a just and equitable resolution. Okay, that's essentially how it happened. As our technology improved, we were able to start recording these decisions, and they weren't just like one sentence conclusions. It would be like an essay of sorts where the judge, the person who decided the case, actually sometimes they would appoint people. Actually, they would appoint recorders, professional recorders. I forgot about that. Reporters. That's right. Reporters who would write down the facts of the case, what the main rules were that were applied, and how the judge analyzed them, and what the outcome was. So they were reported and then recorded in on paper and now on the internet. So it's technology has had a big impact on the development of common law and the ability of it to be disseminated to the public so other people could read and see what the law is in their community. Common law is an example of formal rational decision making that, if you remember the categories of decision making that Max Weber developed for us, this is formal rational decision making because you have a legal professional, a legally trained judge who is applying in a logical, reasoned fashion a rule, and it is consistently applied. So this type of law is very predictable. That is its main benefit, is that it provides a lot of predictability. People can know the outcome, the likely consequences of their choices, and that allows society to function with order and peace and stability. So when a judge makes a decision or the jury arrives at a decision, that decision becomes precedent. That's what precedent is. It's the ruling of a court applying a principle or a norm, a custom, a tradition to a specific set of facts and arriving at an outcome. That becomes a precedent. And thereafter, any other time a situation arises that is very similar or the same as one previously dealt with, whatever the outcome in the previous case was will apply again. So that anytime you have a breach of contract case, for example, there's a list of precedents that apply to all breach of contract cases. It's contract law. So we'll talk about these different areas of law, contract law, tort law, property law, criminal law later on, but they all embody a precedent, a set of precedents, rulings, decisions of a judge trying to resolve a dispute. Okay. Common law can be changed, and every now and then it does. Norms of society change, so sometimes common law changes. But because its chief benefit of common law is its predictability, courts are very reluctant to change common law. They apply something called the principle of stare decisis, and that's Latin for let the decision stand. We would not have predictability in our society if laws changed all the time. So courts do pretty much everything they can not to overrule old decisions. We hold on to the old decisions. And that's why it's really important that they are reliable, logical, and valid decisions, well thought out, made by legally trained individuals, because it forms the fabric of our economic system, provides us with a lot of predictability. As far as the history of American common law goes, it came from English common law. I mean, the colonists brought it over from England, and it just became part of the fabric of colonial life. There is a pretty good discussion of its historical development in your textbook, and it tells the story. There's no reason for me to repeat it for you. So you just read that through your textbook. I do want to emphasize a couple of things just from my own law practice. These are the important things that I noticed that I think are important for you. One is William Blackstone. He's kind of later in the history of the development of common law through Europe and then into America. I mean, he's a Brit. He wrote in England. But Blackstone was an advocate for the equality of common law. So he's making it equal with the legislation of England, the proclamations of Parliament and the King. Now, that's a different type of law that was, historically considered to be more valuable than just common law, but not to William Blackstone. He saw that as being central to the ordering of our society. And so through his advocacy and scholarship, he brought common law up to par with statutory law or legislation, and he compiled all these decisions of English courts into these books. I think there's at least 4 of them. They're really thick and they're categorized by subject matter. And it was an effort to kind of get all the law of England in one spot. And because we had a printing press by this time period, they're all in these big books, these big bound volumes, and lawyers study it. And that's how they learned the law. You go and you study Blackstone and see what English common law was, because that got imported here to America and became American law. Of course, America's has some deviations and differences, but that's the history of how America got its common law. It's kind of come into its own, but anyway, that's a critical part of common law, was being kind of derived from Blackstone's commentaries. And he's still quoted. I mean, you can look up a decision of the U.S. Supreme Court from 2024, and you will probably see Blackstone's name every now and then. He's a big deal. Okay, and so another thing Blackstone came up with was the concept of binding precedent, that now we have all these things written down in these decisions. Lawyers can go and study them and then guide their clients, advise their clients on the choices their clients are making. And that's very valuable. So now whenever the court of last resort in any particular jurisdiction writes out a report of a decision, it's bound in books still. Just, we had Blackstone's commentaries. Now we have these case reporters for every single state in the United States of America. And they actually are still on paper. You can still get them hardback in a library. Most often people are getting them online, like on, I put some of those websites, the repositories of Westlaw Lexis, Google Scholar has them. So you can see them, lawyers study them, and then they advise their clients based upon those prior decisions. And that's how the sort of the predictability of common law gets accomplished. Okay, next one is constitutional law. And all that is just the Supreme Court's interpretation of the Constitution. That's what constitutional law is. It's pretty well explained by its own title. So you could consider constitutional law a subset of common law because it is a court interpreting and arriving at a resolution. It is dispute resolution because it's a dispute over the meaning and application of the U.S. Constitution. So it is dispute resolution handled by a court. So in that way, it's very similar to common law. The distinguishing feature then becomes that quality of it being about the U.S. Constitution, the meaning and application of it. So that's how it is known as constitutional law, because it is about interpreting the Constitution through a dispute resolution before a court. Okay, that's how it's kind of the same as common law and kind of different, right? But in order to really understand what constitutional law is, you got to know the history and structure of the U.S. Constitution. this isn't a history class, so I'm not going to lecture on the founding of our country and, how we had Articles of Confederation and scrap that, start over, write a constitution. That's for history class. What I do want to emphasize are just a few aspects of the Constitution that will help you understand what's in your textbook a little better. Okay, first of all, the U.S. Constitution, the whole point of it is to define and limit the power of the national government. That's why it was written. There's a principle of political science called limited government, and it means that the governments of American society are limited in their power by a written document. And that written document is a constitution. Our national government, its powers are defined and limited by our national constitution. Each state has a constitution. So the powers of the state government are defined and limited by the state constitutions. So when we're talking about constitutional law, we're interpreting the power of our government and what it can and cannot do. That's the whole point of the Constitution. And it's supposed to be, and it is, a reflection of what the people of our country wanted in 1789. What did we want our government to be able to do at that time? So it's a reflection of popular sovereignty. The will of the people as to the power of their government is set forth in the U.S. Constitution. There you go. It has 7 articles, the original Constitution, 1 through 7. And each one of those articles either establishes a branch of government, like the first 3, they establish the legislative branch or Congress, then the presidency, the executive branch, 3rd, the judicial branch. So it establishes these 3 branches of government. It entrenches principles of federalism and separation of powers. And then the remaining articles kind of go on and set the parameters for how the national government is going to relate to the state governments, the way the state governments are going to relate to one another. And then there are some aspects of due process protecting the rights of individuals, but there is no Bill of Rights in the original Constitution. That was not part of the original. We just had those 7 articles to start out with. But if you know your history, there was a big debate between a group of people known as the Federalists and their naysayers that we now call anti-Federalists. They were not called that at the time. But anyway, it was that debate, that battle that later gave us the Bill of Rights. And we'll come back to Bill of Rights in a sec. But another aspect of the Constitution I'm highlighting, the Constitution is supreme law. So if you've got these 3 types of law, common law, legislation, constitutional law, if you ranked them in terms of binding power, you would put constitutional law at the top, because no common law decision is valid if it violates the Constitution, and no piece of legislation, state or federal, is valid if it violates the Constitution. So that makes constitutional law supreme. All other laws subordinate to the Constitution. The Constitution itself can be amended. And you know that because you know that we have various amendments that you've probably studied in other classes. It takes a lot to get an amendment accomplished. There's a couple of different ways that people can go about amending the Constitution. Most often it involves a proposal by a member of Congress. And if there's enough support in Congress, they'll send the proposal out to each state and the states debate it. And if 3/4 of all states approve of the amendment, it becomes an official amendment to the U.S. Constitution. And we've got 27 of them. So the Constitution can change, which means constitutional law. It can change. It doesn't happen very often because it's really hard to amend the Constitution. But it can be. So it still offers that sort of predictability that common law offers, because the stare decisis principle is applied by all courts, even when they're looking at interpreting the Constitution. So it does change. They try not to change it But from time to time it does. Now, there are political arguments that constitutional law is just simply changed on the whim of the judge. And I'm not going to get into a big discussion of that political debate and whether the U.S. Supreme Court has gone off the rails or not. That's not what we're here to do today. But I do want you to understand something that your textbook does not really cover. And I think this is pretty important for you all going into your various majors. There are different philosophies on how the Constitution should be interpreted. And that conflict in philosophy is what you see happening in the conservative versus the liberal. I hate using those terms, but that's what you're seeing in the media. So you think about the conservative versus liberal justices. It's really just a conflicting philosophy on how to interpret the Constitution. That's all they're doing. So one side, it looks at the Constitution, and I've got this in quotes, like dead, which obviously is this piece of paper. So anyway, dead argue by analogy, right? It means it doesn't change, that it's sort of, its meaning is locked in to what the founders of our country intended their words to mean, that its meaning is circumscribed by the historical setting of its original writing. So whatever was the tradition of the United States of America when an amendment was written or when the original Constitution was written, that's the meaning it has 250 years later today. That's what original intent is. And there are many members of the U.S. Supreme Court, very intelligent, well-meaning, good people who just think that it is not the place of judges to make the Constitution adapt in any way to new values and new beliefs. They would rather see elected representatives amend the Constitution and give it the meaning that is more modern, that be the way new rights are recognized, new liberties are recognized, would be through amending the Constitution. So that's one philosophy. The other is to see the Constitution as a living document, one where we're not limited to just the meaning that the founding fathers had when they wrote the words, a few hundred years ago. And it's not that the court is going to ignore the original intent of the framers at all. They aren't ignoring it, but they're just recognizing that those people could not possibly have known what life would be like in 2024. And so we have to look at the spirit of the Constitution, what type of freedoms were important to them. Even if they didn't write it all down, they valued certain freedom of thought and freedom of movement and freedom of choice even then. And so you allow some adaptation to happen when you're interpreting the Constitution. And that is terribly not an eloquent description of the philosophy. So I tried to get a better one for you all. This is a quote from the U.S. Supreme Court decision Obergefell versus Hodges, where Justice Stevens describes his own philosophy for interpreting the Constitution. And I thought I would include that in my lecture so that you could see what we're talking about. I'm not going to read it. Okay, so those were the kind of the highlights of things I wanted to really draw your attention to about the Constitution, but please do pay attention to your textbook on that. Let's go now then into the Bill of Rights. Now, I told you the Constitution can be amended, and it has been. So you've got the first 10 amendments to the Constitution that are known as the Bill of Rights. And you all were instructed to watch a video called The Story of the Bill of Rights, so you can learn, how they came to be and why they came, part of that Federalist, anti-Federalist debate. But we got them in 1791, and they only applied to the federal government because if you remember, The Constitution is the document that defines and limits the power of just the federal government, not the state governments. So those Bill of Rights were just additional limitations on government power that the Anti-Federalists insisted upon before they would ratify the Constitution as a whole. That's what they are. So as you watch the video, use your textbook and learn what each of the first 10 amendments contains. And then there's a fairly good discussion of how those 10 amendments have been interpreted and what their current meaning is. I'm going to leave that to the video and textbook for you to learn. What I'm going to spend a little bit more time on is the Reconstruction Amendments. I'm talking here about the 13th, 14th, and 15th Amendments that came about shortly after the Civil War. They're called Reconstruction Amendments because that's when they were ratified, during the Reconstruction era of our history. They were part of the political agenda of the party known as the Radical Republicans, or the more radical wing of the Republican Party. So Abraham Lincoln was the kind of the founder of the modern Republican Party, and there was sort of a radical wing, like maybe a more progressive wing of the Republican Party. A very different Republican Party than what we have today. Their platforms are different. The names stay the same. Okay, so part of their agenda was to ensure that the former Confederate states don't go back to their terrible ways, and that they're required to ensure actual true equality for all human beings. So start out, Abraham Lincoln, the only time a U.S. president has ever proposed an amendment to or maybe just the first. I think it's the only time American president has ever proposed an amendment to the Constitution. Abraham Lincoln did it with the 13th to prohibit slavery. The 14th Amendment came after his assassination. The Republican Party had power, control of Congress at the time, and they proposed this amendment to provide not just ending slavery, but now guaranteeing equal rights for former slaves. And then the 15th Amendment came just a couple years later with formally recognizing the right of citizens, all citizens, regardless of race, to vote. Each of these three amendments has a little clause at the end called an enabling clause, and it enables Congress to pass laws that will enforce the provisions of the amendment. So these clauses give greater power to our national government to make sure true equality is provided by our Constitution, regardless of one's race. It was deemed necessary by the Republicans. We're not just going to make these amendments to the Constitution. We're going to make sure Congress has the authority to back it up with legislation that can be enforced. So that's what those clauses are for. Okay, I'm highlighting here some provision or some specific language that you're going to see twice in the Constitution. In the video, they talk about this. I'm emphasizing it because it's really important. The Fifth Amendment, limiting the power of Congress, says that no person shall be deprived of life, liberty, or property without due process of law. That is known as the Due Process Clause. And it is a catch-all phrase to ensure basic fairness in any sort of government activity. When the 14th Amendment was passed, Congress wanted to make sure that the state governments were likewise limited in their power. And so they added this due process clause to the 14th Amendment, and it applies to the states. Again, it is a catch-all language, due process. What does due process mean? You got to get more specific. There are some basic tenets of due process, but then there's some pretty specific provisions too, specific rules about what people's rights, due process rights are. And so the courts have to ask, what are those specific freedoms? What specific freedoms are so basic to due process that they should be protected by this sort of general phrase, due process of law? And that process that they go through in determining what those specific freedoms are is known as selective incorporation. So when they ratified the 14th Amendment, they did not automatically sweep in the First Amendment or the Second Amendment or the Third Amendment. They weren't trying to draw those protections automatically into the 14th Amendment. That has happened by constitutional law, by judge-made law, on a case-by-case basis or a right-by-right analysis. The Supreme Court says, we think the First Amendment is so important, or even more specific than that. The freedom of speech is so basic and so important. It is part of basic due process, and therefore we select it as part of the due process rights of citizens that state governments cannot infringe upon. So that's selective incorporation, selecting specific due process rights, and stating that they are part of just the basic freedoms that state governments cannot take away from their citizens. All right, so that was constitutional law. Now we're going to move into legislation. We will circle back a little bit to the interplay of the Constitution with legislation in a minute. But let's just make sure we all are on the same page with what we mean by legislation. Well, legislation is the work of Congress. So that's why I've got these pictures. That's the picture that you see in the bottom left screen of the current sitting 118th Congress when they first got underway back in January. That's them at work. So legislation comes about through the democratic process. Elected representatives at every level, federal, state, and local, get together, write laws, debate them, and go through the process of how a bill becomes law. And then they are codified and added to a written code. I've got an image of the U.S. Code, or one volume of it, on your screen. It's got a lot of volumes. It's really big. But they're all put in books, and you can find them on the internet as well. But this is public law. This is the enactment of elected representatives through the democratic process, presumably a representation of the will of their constituents or a majority of voting citizens, what they want their laws to be. They can come about through legislation. So whereas common law, constitutional law happens through the judicial process of dispute resolution, legislation comes about through the democratic process of bills becoming law through acts of the legislature or Congress. They are written and codified, as I showed you on the screen, picture of the book. You can get them on the internet too. And they're often a compromise of, and they're often the result of political compromises. And you all know enough about, the vitriol and all the fussing about politics that goes on in our country. But in the end, the result of legislation is a political compromise. What values we share, what norms we want to apply to govern our society, they are a product of compromise. To get things accomplished, there has to be political compromise in it, in spite of all the bickering. Administrative law is a subset of legislation. We'll spend a good bit more time on administrative law later in the semester. But for right now, just know that there are organizations that Congress or the president has formed. They're called agencies, and Congress or the president will delegate power, rulemaking power, to the staff members of these agencies, and the rules that they write implement the public policies that Congress desires, the people desire anyway, and they're compiled into code of regulations and published for the public to read, and that's known as administrative law, and we'll talk a little bit more about it later in the semester. Legislation changes far more often than any of the other types of law, and that's because elected representatives change and the people's will changes. So whenever society wants a new law or to get rid of an old law or change an existing law, our elected representatives go about doing that through the democratic process, and that's how it's changed. So how they interact with each other is this. I'm going to start out with common law. So common law is obviously subordinate to constitutional law. It doesn't impact constitutional law very often. I honestly can't sit here and think of a huge example or a good example of it, at least in modern times. But you should know that a judge resolving a dispute in, even if it's just a simple economic dispute, he is also bound by the principles of constitutional law, often involving due process and basic fairness among disputing parties. So common law is subordinate to constitutional law. But sometimes the common law gets so standardized that legislatures will codify it. This is called codification. And all that means is that elected representatives take a common law principle and put it in a bill and send that bill through the democratic process so that it becomes an enactment of legislation. They just take common law and convert it into legislation because it's so standardized. Sometimes legislation can overrule a common law principle. So in that sense, legislation has more binding power than common law does. So again, if you're ranking them in terms of authority, you got constitutional law at the top, legislation, and now common law. But I tell you, William Blackstone would argue with me about the value of common law there. A lot of people would see them all as equals, all three types as equal, but common law principles can be changed by statute. A legislature can change the common law, and when they do, a court is bound to apply that legislation. Legislation, as I mentioned, is the work of elected representatives in Congress or in the state legislatures. The power to make legislation, the power to write laws comes from a constitution. Congress can't just go out and say, hey, we want to write a law that does this. No, they've got to look to the Constitution and say, do we have authority to write a law on this subject? And if they do have that authority in the Constitution, they can go about proposing a bill and debating it and enacting it into law. So legislation is subordinate to the Constitution in that sense that Congress can't make a law they aren't authorized to make by the Constitution. That's an aspect of limited government. Even once they do enact a law, a citizen can challenge it and say this violates the Constitution. And then the U.S. Supreme Court or the federal court system can go about reviewing the legislation and determining whether it runs afoul of the Constitution. That is known as judicial review. And that's how constitutional law comes into play, the power of judicial review. And it is such a big deal, it gets its own little slide. Judicial review is something that we all take for granted today. The notion that courts can look at an act of Congress or an act of state legislature and say, hey, this violates individual rights and we're going to invalidate it. We take that for granted. But they didn't originally have that power. The power of the courts to review the works of a co-equal branch of government was not really there in the Constitution. It never says in Article 3 that the courts have the power to strike down an act of the legislature. It was something that came about through a U.S. Supreme Court decision known as Marbury versus Madison. And it is an aspect of the doctrine of separation of powers because you have a court system acting as a check on the power of a co-equal branch, Congress. They're saying, okay, Congress, either you didn't have the authority to make this law because the Constitution doesn't give you the authority to do it, or, hey, you may have had the authority to do it, but you're infringing on an individual right, and therefore we're going to invalidate it. right? That's what judicial review is. And the ability of the court to do that is not plainly set forth in the Constitution. It is just sort of recognized now because of this one U.S. Supreme Court decision, Marbury versus Madison. And I'm going to assume that you guys have heard of that case and know all about how it went down. If not, Google it. There's about 10 zillion videos that describe Marbury versus Madison. So I don't really feel the need to take up your time going over it now. The important point is this is the biggest case, U.S. Supreme Court case basically ever decided, because it is where the power of judicial review was first done, recognized. And thereafter, it's never been overruled. And thereafter, the body of constitutional law was allowed to really flourish and develop. So now, having the power of judicial review, how has the court used it? In what ways have they used it? And a good bit of the early constitutional law had more to do with the power of Congress to do something, or the power of the president to do something. It wasn't until mid-late 1800s where you start seeing the recognition or the development of substantive rights. And so it's at that point that the judicial review starts to adapt and say, well, this law isn't valid because it infringes on the freedom of contract, or this law is invalid because it infringes on the right to marry, the freedom to marry, or the freedom of parents to make choices about their children's well-being. So those type of substantive rights were first recognized in towards the end of the 1800s, and certainly through the 1900s. Before that, when we talked about due process, we were just talking about procedures, like the ones in the 4th, 5th, 6th, and 8th Amendments. Now we can talk about substantive due process as something separate from procedural due process. And we'll have a good long discussion about procedural due process and criminal process later in this semester. But real briefly, we're going to talk about substantive due process now. Maybe some more later on. Recognizing rights, substantive rights, it comes about through rubrics or tests that the U.S. Supreme Court does in an effort to balance out the power of government to work for the common good, balance that interest against personal interest, individual freedom, because that's what the court is essentially doing. It's trying to balance these two competing interests: common good, individual rights; public safety, individual rights. So that balancing requires a rubric or a test that the courts will apply. And the court system, we're dealing with separation of powers, and the courts have to remain in their place. It is the work of legislatures to pass laws that reflect our norms and values. It's not the place of courts to determine what our values are, to tell us what our values are. That's what legislatures are doing. They are our elected representatives, and we've charged them with that activity to do. So courts take care not to overstep their authority and interfere with the democratic process. State governments in particular have something called police power to enact laws that reflect the values of its citizens. But when governments go too far in terms of infringing on individual rights, that's where these balancing tests will come in. So let me show you what they are. They exist on a spectrum. And at one end of the spectrum, you have something called strict scrutiny, sometimes also called rigid scrutiny. And it is really hard for a law to survive strict scrutiny. It's this obvious from the title. It's strict, it's rigid. Okay, so it's hard to win. At the other end, you've got mere rationality or rational basis tests. And that's pretty easy for a law to pass just to say it is a rational law. It's not arbitrary. Okay. And then somewhere in between, you've got intermediate scrutinies, and no one really knows exactly what that is. Just we know it's not strict scrutiny and it's not rational basis. It's somewhere in the middle. Strict scrutiny is a situation where the government has a burden, a high burden to justify itself, to justify its enactment. And the burden is high because the law, it either treats people differently by class, by grouping, or it infringes on a very fundamental freedom, one or the other. So you have in the 14th Amendment protection for the equality, right? It's called the Equal Protection Clause, right? Everybody should be treated the same regardless of race, gender, ethnicity, blah, blah, blah. When a law treats classes or groups of people differently on the basis of their race, ethnicity, or religion, that law will be struck down almost certainly. There's only one time in the history of the United States of America where a law passed strict scrutiny, and that particular time is so notorious. It's known as the Korematsu decision, and it has been overruled. So the one time it happened has been overruled and criticized throughout all aspects of our government history. Okay, so where strict scrutiny applies, the law is going to fail because we can't have those type of classifications. They are inherently unfair. When fundamental rights are infringed upon, strict scrutiny will apply. So the big exercise really comes down to whether a specific right is fundamental. And it's fundamental if it is just something that's so inherent to what it means to be free. And there are certain examples of that that you see just looking at some of the decisions, Supreme Court decisions through history, recognizing, choosing your occupation, choosing where to live, choosing who you're going to marry, deciding how many kids you want to have, where you want to send your kids to school. Things like just really the basic choices that people ought to be able to make in a free society. Those are fundamental rights. And where fundamental rights are implicated, strict scrutiny applies. Intermediate scrutiny, that sort of no man's land in the middle, will be applied to classifications based upon gender, illegitimacy, and often immigration status. It's still the government's burden, but it's a little bit easier to get by with those types of classifications. And then last, you got rational basis, which applies to everything else. So, and it's essentially a test saying Congress was or was not acting arbitrary or irrational when they passed this law. They had a legitimate purpose for what they were doing. For strict scrutiny, the government or the legislature, Congress, if it's the national government, state legislatures, either level, when strict scrutiny applies, they would have to show a compelling interest that is narrowly tailored to accomplish. The law is narrowly tailored just to accomplish that purpose. It is the least restrictive means of accomplishing that purpose. That's why it's so hard to satisfy. Compelling is a big word. I mean, it means a lot. It has a lot of meat to it. So that's why it's really hard to win those cases. Versus, are you acting rationally at the other end of the spectrum? That's easy to satisfy. And then intermediate scrutiny, who knows? It's a toss-up. Cases go both ways where intermediate scrutiny is applied. I'm not going to talk about this case in the lecture, but if you're having any problems understanding what we're talking about with judicial review and these tests, standards of review, this case, Loving versus Virginia, is a really good one to read. It's very easy to read. It's a sweet case involving a sweet couple and their right to get married. It happened during a time where races were considered so different that people of different races couldn't get married. And that's not true anymore. It wasn't true then, but it's universally accepted now. But in the 60s, the conflict was, you had all these states that made interracial marriage illegal. Um, it was, those laws were starting to change with the civil rights movement. But this one couple was not going to sit and just wait for Virginia to wake up and repeal that law that kept them from getting married. So they challenged it as a violation of the Constitution. And their argument was based on both equal protection and the fundamental right to marry. So when you read the decision, you can see how the government's looking, how the Supreme Court is looking at the equal protection of the races and asking the state of Virginia to justify its discrimination on the basis of race. And they're trying to say, Virginia says, no rational basis should apply here because states have the authority to regulate marriage. And then Mr. and Mrs. Loving and their lawyers say, no, the racial classifications are illegal under the 14th Amendment. And so it doesn't matter. You can regulate marriage, but you can't regulate it in this way. You can't treat the races differently. And then also on top of that, you're talking about a person's right to get married. And the right to get married is something that had been recognized since the 1800s. So that obviously is a fundamental freedom, and any infringement upon it must be subject to strict scrutiny. So that was the argument, and you kind of see how that all plays out, and it will make it crystal clear how that works. So if you're having any trouble understanding those standards of review, Google that and read the decision. Or obviously email me and ask me, and I'll be glad to do a Google Meet or Zoom meeting, whatever you need, and we'll talk about it some more. But that's all I have for this lecture. And I hope y'all have a good day.